Okay, welcome to UBC Law, to all you TRU students. So today we're going to talk about kind of basic principles, and it's kind of a summary of the things we've done in the course. So news of the week for this week, kind of the usual stuff. Best practices for boards and individual directors. We'll certainly twig some thoughts around things we've already talked about. This, I think, is very helpful. It follows on many of our discussions the need for a tailored code of conduct. So actually creating a code of conduct, I think will help you and help empower you as a general counsel if you get buy-in to do so. It will also, it's usually will be a shared responsibility with HR, but you can also deal with things like investigations and how to deal with them, so that's baked right into the cake and you don't have to invent it as you go along, which of course as general counsel it's a dangerous thing to do. So a tailored code of conduct can include a lot of things and is probably worth your effort at the front end of being a counsel. A piece about whistleblowing in Canada. We certainly talked about whistleblowing generally, but a lot of those examples are American. So it's good to have Canadian reference points and slightly different from other. We don't have exactly the same attitude. And again, going back to Law Society rules. In the United States, there's much more responsibility on counsel to whistleblow, or it's much more accepted. In Canada, it's more elevate the issue as far as you can, and then if you're stuck, quit, as discussed. Interesting piece, you decide for yourself what you want to make of it, but that kind of ongoing debate, a lot of which we did last week, around practice in-house or in private practice and what goes into that decision. In what would you do? I know I just can't resist Elon Musk. He's certainly been a theme of the course. New Tesla chair on Elon Musk, so there's a new chair of their board. I don't think he poses any challenges. Okay, that's all I can say from the other things we studied and looked at this semester. We talked a lot about Judy Raybould-Wilson as general counsel to the government of Canada as a way of understanding counsel-hood and the issues and what it's like when your CEO really wants you to do something and the kind of pressure that can be brought to bear and the ethical and other issues involved. And it was a much better fit, I think, than any of us expected it to be. The issue here is just to remind you of what's in the Law Society rules, that a lawyer must not use any device to record a conversation between a lawyer, a client, or a lawyer and another lawyer without first informing. Obviously, that's not what Judy Raybould-Wilson did, but she wasn't a lawyer in the sense of being a member of the Law Society. She's an honorary member of the Law Society of Ontario, sort of not an actual member, so there's no sanction. There are further arguments, I think, that she in the recording, she wasn't necessarily acting as lawyer. She was just being told what to do. Now, that's not wholly true, because she was yet again saying, my advice to you is that you're breaching the law. So you'll have to decide for yourself what you think. But technically, my guess is she's going to be fine. But the issue does definitely exist for all of us who are counsel and members of the Law Society. So kind of, concluding, because next week we're going to be doing the game, just sort of this notion that when you're in-house, especially if you're general counsel, you have great power in many ways. You're respected in a great many ways, and therefore you do have commensurate responsibility. We've talked about this paper, but we haven't gone through it. I haven't gone through it exactly, but I think it's core. The pivotal role of corporate counsel in promoting corporate integrity and professional responsibility. And it really takes us through the various lawyering roles, all of which in-house counsel do. And it's incredibly multifaceted and incredibly broad, as opposed to kind of the more narrow and more limited roles that law firm lawyers take. Although sometimes they may look more deeply or have a greater expertise in this area or that. But they're not as broad, and they don't have as broad responsibilities, and they don't have as direct responsibilities. That said, as counsel, you not only have those responsibilities because you're in-house, you also have all the other Law Society rules that apply to you, as we now know. And then there are non-legal roles, which are nicely documented. Legal services marketer, ad hoc planning advisor, ethics counselor. That's actually a rather big one if you're in-house counsel. And crisis manager, because if there is a genuine crisis, it's almost automatic that people look for a lawyer in the room. Even if they're not sure why they need a lawyer in the room, they will want a lawyer in the room. Certainly sophisticated corporate executives will. Then kind of post-Enron and the Sarbanes-Oxley era, which we've certainly talked about, and the whistleblower responsibilities, and sort of ending with, I think, something in our context that we need to, that we've sort of harped on. What is the status of in-house counsel with respect to insurance and with respect to privilege? So we've gone through all of those things, and I think we have some fairly clear answers. Certainly in Canada, there's equal privilege to any other lawyer. It's not litigation privilege, but only as applies to when you're giving legal advice, and not when you're wearing one of your other hats, like ethics counselor, for example. That may not be acting as a lawyer. So, and then the other thing that I think is lacking, and that we've talked about, is it would be nice if Law Society rules and insurance rules more particularly applied to in-house counsel. Now, I just want to talk about kind of some little parts of this paper that I think are interesting. Kind of this quote, sort of from before the turn of the century, in the 19th century, to be general counsel of a major railroad after the Civil War was to occupy a position of great prestige and enormous salary. So although it seems that law firms or kind of were the place you practiced law. That wasn't necessarily the case. General counseling and in-house counseling, particularly when you were in a major industry, and I suggest, media and sports is kind of the current equivalent of railroads, is a big deal. And according to this, the bar's best and brightest, including judges, and remember this in the 19th century, were looking for those positions in railroads. In fact, Abraham Lincoln was a railroad lawyer, and as mentioned before, Clarence Darrow was as well. So I don't know that you can do much better than that. There's this interesting piece here about companies recognizing that lawyers' skill sets are beyond the law and what they've learned in the law and in practicing law and in analyzing law and in negotiating law or arguing law or taking advocacy positions made them useful for a whole lot of other things. And at the same time, lawyers, as we discussed last week more particularly, were big firm lawyers were discovering what's referred to here as the tyranny of the billable hour. Part of another quote, I just kind of go through main points. They all tie into things we've talked about. Part of the complexity of the role of legal advisor is that you're not just dealing with your boss, the CEO. You're not just dealing with the shareholders and shareholders meetings, but very often you're dealing with directors in a directors meeting context, or sometimes outside a directors meeting context. And this is why your responsibility is to the client, and the client is the corporation, not any one of those people. And that's why you need to be very clear about where you're getting your instructions and what you're doing being not in the best interest of whoever gave you the instructions, but in the best interest of the corporation, because no matter where instructions and discussions and points are coming from, you are the lawyer to the corporation. And if you trip up on that, you trip up big. We've talked about counsel as investigator, the desirability of a broad vision in counsel. So I certainly endorse that. And whether you have a broad vision or not, you better develop one, because what you miss can hurt you. Again, there is a certain comfort in the narrowness of law firm practice. Here's a file, do the file, end the file, start another file. It's very focused. It has a beginning and an end. Whereas part of the problem with being counsel or general counsel is there is, it's very overscoped. It can be anything and everything that is an issue or could become an issue, and you are, in essence, tasked with responsibility over all of it, because if you don't do it, the CEO will come into your office and say, how come you didn't see that? How come you didn't notice that? That's why you're here. The good news on that is the general counsels and counsels themselves, sometimes below the general counsel, do tend to sit on top of the corporate hierarchy or pretty close to it. We're rarely taken for granted. We're usually very senior, very appreciated, and very listened to, at least as a going-in position. Key point made here is kind of know what your limitations are and go to outside counsel when you need to. So issues that arise when working as or working with in-house counsel. I want to run some scenarios. I know we've done the entire semester around scenarios, but here are some that I made up for you to think about. You are the young general counsel of a publicly traded Canadian telephone company. You were previously outside counsel to the company as an associate, let's say, in a big Vancouver law firm. You're hired by the chief operating officer of the company, who is new to the company themselves and came from another telephone company. You've got a terrific relationship with the COO, and he's really good at marketing and sales, or she is really good at marketing and sales, but not particularly knowledgeable about legal matters. COO comes to you with views on a dispute with a contractor who's done work on their home. And then, so what do you do there? Pretty tough. This is someone you're really close to. So think about it. There's going to be enormous temptation to give some sort of advice. And part of the problem is you're still a lawyer, part of the law society. And if you give advice, this is now your client. And there's a potential conflict between, although it may be benign in this case, or at least so far into the facts, but here you are, you've got the client who's the CEO and the client who's the company. You now got two separate clients, and they are, it is not really very smart or very proper to act for both of them. Now, you don't necessarily have a conflicting issue that's direct, but better not to get into this problem in the first place. And that's how it usually starts, something benign. And now the COO thinks he can come to you about anything because you've allowed him or her to do that. So now COO comes to you about a dispute with their former employer, which was a family-owned private telephone equipment manufacturing company. And the COO had been given some shares in that company and is fighting with his old bosses about the value of those shares because he's now come over to your company. He got, let's say, or she got 25,000 shares, and the COO would like to sell the shares back to his or her old company for $10 a share. So that's $250,000. But COO thinks it's actually worth twice that. COO eventually becomes CEO. Nothing's happened on those sale of shares, of his shares. But suddenly, your company decides to buy his old company. And in that deal, suddenly, instead of $10 a share, and remember the COO, now CEO, said, well, it's worth twice that, which is $20 a share. Suddenly, the valuation of the shares are $100 a share, 5 times as much, and this is going to be paid to your CEO if the deal goes through. What do you do? And, have you taken the bait? Is the CEO your client? Do you owe them a duty of confidentiality? Or have you been smart and you know your duties to the company? So do you do nothing? Do you tell the story to your CFO or outside counsel? Do you go to the chair or the chair of the board or the chair of the audit committee? Do you tell the story during a board meeting and after asking the CEO to leave the meeting? So think about all of those possibilities. These answers aren't absolutely crystal clear, except I would say nothing is the wrong answer. Just talking to another employee or outside counsel without taking further steps is also, it's not the wrong answer, but it isn't the right answer. Likely C or D are your right answers. Scenario 2, you're the first general counsel, so you're a young general counsel in a privately held Vancouver startup company that makes virtual reality headsets for video gamers. You'll recognize what I've based these facts on. Your company launches with an enormously successful Kickstarter campaign that shows the potential of the market, and the world's largest social media company, this actually happened, takes notice and offers to buy 55% of the company, with the founding shareholders, including the CEO, holding 45%. You do the deal and you remain as general counsel. You receive new stock options. The majority shareholder has a majority of the board seats, so that's the social media company, and the company keeps growing. 6 months later, the social media company parent offers to purchase the remaining 45% of the shares. The founders group, of which you are one, is interested but feels the price is too low. Negotiations happen, but an impasse results. After kind of a nasty board meeting, your CEO is asked by the chair, who is from the social media company parent, to resign. CEO refuses to do so. And the board holds a special meeting with a view to terminating the CEO. The chair advises you that the CEO will be terminated, and you will be asked to be the new CEO. Your CEO has heard about the impending events and along with, but doesn't know that you're going to be CEO. Or have been nominated, and along with the other startup shareholders seeks your advice regarding the commencement of an oppression action or a derivative action against the company. What do? Nothing. Advise both the startup group and the current board that you have a conflict of interest. Resign. Advise the board that their proposed actions are likely improper and not in the best interest of the company. Very tough. All of these answers can be right. Probably A and B are the rightest because you're already compromised. So the advice that you're going to give, how you keep that straight is a real challenge. Now, if you were looking for the advice, to give advice, I mean, the one thing you probably could fairly say is read Duluth Holdings versus Air Canada, where Air Canada got rid of a minority shareholder CEO who once owned the whole company, and the court held that Air Canada was acting improperly. I've given you all the facts so that you can understand that, but I don't have to go through it in any huge detail. In my view, the conduct of Air Canada, the parent, majority shareholder, and its nominee directors that Air Canada controlled could be found to constitute oppression. So, probably the majority shareholder would do well by reading Deleuze, but you've already been, you're between and betwixt the two positions. So resigning or complete transparency to everybody and say, hey, I'm compromised here, you all need outside counsel, and it ain't me, is probably the rightest of the answers. We've talked about Nevison. I just want to make sure that you actually see the case, know where to find it. Very long decision of Mr. Justice Abreu, who is a classmate of mine at McGill way back when. Essentially talking about potential corporate liability for alleged breaches of both private and customary international law. That key is that you, as counsel, are responsible for that. You are responsible to know what the international law is in the jurisdictions that your company operates. So again, this all goes to the breadth of what's happening to you. Here's the structure of Nevison, which is interesting. The company that is allegedly doing the bad thing is this company, but it is a 60% subsidiary of a whole bunch of 100% subsidiaries. So, Nevison is only remote because there's 4 structures, but they're all structures they control. Nevison Resources holds 100% of Barbados, holds 100% of Africa, Barbados, holds 100% of Eritrea, which then holds a majority of 60% in Bisha Mining, which is where these things were happening in that project. So, there is a fairly cogent argument that they are responsible because they're the majority all the way through. They control all those boards. Some of them they completely control. So these are the claims. Here's the Court of Appeal, which agreed. And then it was going to the Supreme Court of Canada, where there is a little bit of a ban. This is what is there. I will tell you that there was a webcast ready to go. I didn't turn it on, and now the webcast is gone, as we know. I should have, so this was the webcast of the arguments. I should have watched it at that time, if it was indeed available. So a bit more on your responsibility to think about these issues, which may seem really remote and for companies removed, but they're not. They ultimately land on your desk. So just want to recap kind of a lot of the things we've done and principles to think about. We remember the course in 2 cartoons, how to stump a corporate lawyer. One sign points to legal, the other sign points to ethical. And then this wonderful cartoon about the different hats you wear and the confusion that can cause you as in-house counsel, where it's always clear who you should be extremely clear who the outside counsel is acting for, also acting for the company, but taking instructions in certain ways. So the perspectives of in-house counsel and outside counsel are different. We've talked about this considerably. The basic issue is conflict of interest. That is the basic problem for outside lawyers as well, but it manifests differently because when you're in-house, you're being paid by the company. You don't have any other clients, so you don't have a traditional conflict, but the test is there a substantial risk that your representation would be materially and adversely affected by your own interest? And that, if you have share options, if you have big options, if you just need your salary to get through to next week, all those things can affect your judgment. And conflict of interest is absolutely critical. D, a lawyer has a personal financial interest in a client's affairs. It can be a conflict. And you certainly have, if you work for a company as in-house counsel, a personal financial interest, and that much more so when you have shares. So it's a pretty basic problem, and in a sense, it contradicts the old saying, a man who is his own lawyer has a fool for a client. In a way, you can argue that the company has, you are the company, and you are in a sense hiring yourself. It's not totally true because the company is more than you, but you see the point. Another basic conundrum that we've talked about is that good governance is invisible and is measured by all the problems that don't make the newspaper and that people don't hear about, where bad governance is super visible, results in explosions, and everybody kind of knows about it. There's a kind of deeper problem. What is good governance? And so here are kind of my rules of the road. Don't assume the worst. Find out what's going on. Transparency is always good, and that may not be your first instinct. Transparency, as long as it's serving clarity, there are some things you have to keep secret. But transparency for clarity is usually a good thing, and especially with the board. If you're dealing with the board's entitled to everything. Shareholders aren't entitled to everything, but the board generally is. That said, contradiction, respect confidentiality completely. So you have to understand what is confidential, what might need to be privileged, and because that has to relate to your legal advice. If there is information to be kept privileged, you need to find a way to make it subject to legal advice and put it in that context. Don't share information unless it's clear that you can. This is a big one. 5, don't take sides. You're there in the best interests of the company. You're not there for this person or that person, this executive or that executive. So the best interest of the company or the corporation may force you to do certain things, but that's not the same as taking sides. Your side is the side of the company. Don't look at conflicts of interest as purely technical. Give them wide ambit. And that's kind of a better way of identifying them and staying out of trouble. And the job 1, not job 7, is actually identifying issues. So hopefully that helps. Now, rules over the course that we've learned. You are a lawyer first. That's the hat you were trained for. And your first duty, in fact, is to be a lawyer to the Law Society, and none of those obligations are mitigated by you being in-house, and you do get privilege. And I always find it useful to say this to you again. A lawyer is a minister of justice, an officer of the courts, a client's advocate, and a member of an ancient, honorable, and learned profession. Act that way, and the fact that you are in-house does not change one iota of that. Number 2, rule of the road: avoid conflicts. Understand them. Understand that to some extent there is an inevitability when you're in-house. But that doesn't change your responsibility to identify them and avoid them. and disclosure and disengagement are extremely useful tools. And outside counsel is a very useful tool. Part of this, you act only for the company and act only in the best interests of the company. Next, understand what hat you're wearing. When are you counsel and therefore carrying privilege? When are you not counsel and doing something else? And just have a real consciousness of what hat you're wearing at what point. Establish the scope of your hat. I think this is important. I think it is important to, if you come in-house as a counsel, to talk to the general counsel about what scope there is, and maybe encourage that there is a discussion and a meeting with the CEO or with the board so that there's clarity around roles, responsibilities, and rights to investigate, et cetera, and what the appropriate processes are. Understand all of that and create policies accordingly. Obviously, if you're general counsel, the ante on this goes up. Other principles that are worth thinking about that may not be as important as the first four, but are still, I think, very useful for survival and progress, and I think just being a good general counsel, given the scope of things that we are talking about and that were referred to in the article earlier. Being a leader, I don't think hurts you as general counsel. I think it may well help you. Openness, transparency, yes, but here's the key assumption around everything you do, especially if the company's in a difficult or challenging position. Assume everything, project yourself into the future, and assume everything you do will come out and be accurate, that your documents will, and act accordingly when you're drafting things, when you're saying things, when you're doing memos. Assume that it will be seen and write and speak with that as your context. The right side of history. You know, I would like to think that if you were in the Enron situation or you were counsel for Esso in the Exxon Valdez, that you knew what was right and what was wrong and how things were going to turn out. I mean, things arch towards the right side of history. They do, you know, head that way. With the benefit of hindsight, we can see a lot of things that were wrong at one point that may not have seemed wrong at the time. If you really want to be a great general counsel, think about the future, think about what will be accepted, think about how things will be written 10 years or 20 years from now. Not about you, but about the company, because those are the best interests that you're protecting. I saw this, I'm not going to give you the context, but it's a great quote. This is Earth from Saturn. It's all about perspective. We cannot know how we would have acted, but we now know how we should have. You don't want to have regrets. The arc of the moral universe is long, but bends towards justice. That's what I was trying to say earlier. We all know how we should have acted. Project that into the future as general counsel. This is section 3 of our statute, which of the Law Society Act. It is the object and duty of the Law Society to protect and uphold the public interest, and you're a member of the Law Society. Don't forget the rule of law. It's there for all of us, and it's in our Constitution. Willful blindness doesn't work. Know your company. Don't ignore what's going on. If you see something wrong, you're better off dealing with it than trying to ignore it. You're not acting in the best interest of the company if you ignore it. This came from one of the student presentations. I call it the Yoda principle. One day, next week, I may tell you how I made this slide, because that's a story unto itself. But the Yoda principle is strive to be wise. You may not be as wise as Yoda, but you want to be. And that really is helpful in a counsel or general counsel position. Wisdom is definitely something to aspire to. If it's just the narrowness of your job and doing that well, you know, the lawyers that created subsidiaries for Enron, they were perfectly good subsidiaries. The corporate work was done faultlessly. Everything was registered properly and on time, and everything worked. It's just that if you really looked at it and if you didn't avert your eyes, your wisdom would have told you there's a problem. Governance, not compliance. You have to comply, and compliance is important, but think of it as a minimum standard. It is not the standard. It is the minimum standard. And governance, a proper understanding of governance, will tell you and instruct you and show you how it is the minimum standard. And then I've shown you this before in a different context, but if there's no diversity, if there's no diversity of views, if there's no discussion, if it's all groupthink, mistakes are going to be made, and really big mistakes are going to be made. So I call this principle clones become clowns. If everyone that you're talking to is all saying the same thing, and if the entire legal department's saying the same thing, that's a problem. Something we did at the beginning of the course, but not so much for the rest of the course. I nominated a great in-house counsel at the beginning of the course. I'd like to nominate a second one. Tim Cook in 2014 at an Apple shareholders meeting told off climate change deniers who were in the audience, had bought some Apple shares. And it was a bit of a controversial position to take. Cook said, if you want me to do things only for ROI reasons, you should get out of this stock. Of course, as you've learned in business associations, there is some need to enhance profit, but it isn't. It is a mid to long-term view of the company that you take. So there are things that can even seem generous or almost altruistic that a company can do. Cook was walking that line, and I was just curious to figure out, because my assumption is someone like Tim Cook would definitely have talked to his general counsel about this. So I tried to figure out who the general counsel was at the time. It was an individual named Bruce Sewell, and here's his history. But because of what Cook said, which I have to believe he talked to counsel about, and because of the advice that counsel gave, I would definitely nominate Bruce Sewell as a great in-house counsel, even though I don't know him. Next week, counsel the game. So we'll see you on Thursday. Thanks very much.